Well, good morning, everyone. And as I said a moment ago, for those who'd already joined us, welcome to this, the latest in Cornerstone Barristers series of webinars. This one, Licensing the Private Rented Sector, the Law and Practice of Licensing Designations under the Housing Act 2004. For those of you who don't know me, as will be apparent from the slide, my name is Dean Underwood. I'm a barrister specialising in public law, local government law and housing law at Cornerstone Barristers, with a particular specialism in the licensing of the private rented sector under the 2004 Act. So hopefully you will be in the right place. This, in fact, will be the first in a series of 4 webinars that I will present throughout the month of July, all on licensing the PRS. The first of them will consider designations, and that's why, of course, you're logged on today. The second, in a week's time, will look at applications and fees, a rather thorny question. The third will consider licenses and license conditions, and the fourth then will look at aspects of enforcement, in particular prosecutions and financial penalties. But for the moment, let me take you away from the phonetics of British politics to the world of licensing designations. And so what will we be looking at today? Well, principally, we'll be looking at the process of designating areas under Parts 2 and 3 of the Housing Act 2004 as subject to additional HMO and selective licensing. We'll be looking at aspects of the law and practice. So for the purposes of the webinar, I've assumed a basic knowledge of Parts 2 and 3, although I will still nonetheless be covering some of the basics. As indicated at the top of the slide, the focus will be on licensing designations, and so relatively little will be said about mandatory HMO licensing, because of course that doesn't depend on the designation, but it will be covered in brief at the start. I'm going to provide you with a summary of local housing authority powers to designate areas as subject to these licensing designations. I will give you an overview of significant case law, and the eagle-eyed amongst you will note that the case law that is listed on this slide is in fact all concerning consultation, and perhaps right at the very outset of this webinar that will give you an indication of the importance that consultation plays in the designation process, and we'll come back to those cases in due course. If you have any queries arising in respect of either the webinar or indeed if you'd like to instruct me on any licensing matter, then please don't hesitate to drop me an email. You can contact me at dunderwood@cornerstonebarristers.com or my clerks at teamdan, Teamdan, at cornerstonebarristers.com. So without further ado, let's take a quick look at mandatory HMO licensing. So if you want to get familiar with the law relating to mandatory licensing of HMOs, then you need to look at sections 55 and 254 of the 2004 Act. 254, of course, gives you the definition of what is an HMO, together with Schedule 14. And also the secondary legislation made under Section 55 for the purposes of mandatory HMO licensing, in respect of England and Wales, and that's the licensing of HMOs prescribed description orders 2006 and 2018. As I indicated in respect of the last slide, no designation, of course, is required in respect of mandatory HMO licensing. I note with some curiosity some statements by local housing authorities in some of their online policies that they have essentially chosen to operate mandatory and additional HMO licensing designations in their area, because they don't have any choice in respect to the mandatory licensing of HMOs. They will apply regardless of any designation. In England, mandatory HMO licensing will, since the 1st of October 2018, apply to all HMOs that are occupied by 5 or more persons living in 2 or more separate households, provided the HMO meets one of 3 tests. That is the standard test, as in the standard test in Section 254, the converted building test, also Section 254, and a modified version of the self-contained flat test, all of which, of course, along with other tests in Section 254. The self-contained flat test is modified so that it excludes purpose-built flats in blocks of 3 or more self-contained flats. So in short, if you as a local housing authority want to regulate by way of licensing self-contained flats in purpose-built blocks of flats of 3 or more such flats, then you'll have to do so by way of additional licensing. That's the position in England. In Wales, mandatory HMO licensing still applies to houses in multiple occupation of 3 or more stories that are occupied by 5 or more persons living in 2 or more separate households. So in Wales, the test that applied in England prior to the 1st of October 2018 still applies, in fact, in Wales. But in neither England nor Wales does mandatory HMO licensing apply to Section 257 HMOs. So that's a very brief word about mandatory HMO licensing. As I say, I'm not going to really focus on it because we're concerned today primarily with designations. And of course, mandatory licensing doesn't depend upon any designation at all. So that said, moving on to the first of the types of designation that a local housing authority can make, additional HMO licensing. By way of an overview, you'll find the relevant provisions for additional HMO licensing, along with those of mandatory licensing, in Part 2 of the 2004 Act. And that gives local housing authorities power to regulate HMOs that are not covered by mandatory HMO licensing. And so instantly you'll be thinking, given what I said on the previous slide, well, in that case, then it must be directed primarily at, for example, smaller HMOs, those occupied by 3 or 4 persons living in 2 or more separate households, and Section 257 HMOs. And as indicated further down this slide, they are often the HMOs that are targeted by local housing authorities by way of additional HMO licensing designations. Now, the designations are intended to target poorly managed HMOs and those where either the conditions of the HMO, the occupants themselves, for example, are causing problems either to the occupants of the HMO itself or indeed to others in the local community, members of the public. The material distinction between additional HMO licensing and mandatory licensing is that, of course, additional licensing will depend upon the designation of an area by the local housing authority, as indeed will the type and number of HMOs that are covered by the designation. Whereas the description of HMOs covered by mandatory licensing depends upon the statutory prescription of HMOs. Here, for additional licensing, it will depend upon the local authority's own description of the HMOs that are covered. Critically, consultation is required before the local housing authority can make any designation under Part 2, and we'll come back to that at the end of this webinar. And in addition to that, either general approval issued by either the Secretary of State or in Wales by the Welsh Assembly, or in England, confirmation by the Secretary of State. And I say in England in brackets because, as we will come on to see in due course, in Wales, additional and selective licensing designations already have the general approval without conditions of the Welsh Assembly. If an area is designated as subject to additional HMO licensing, then any HMO that falls within the designation area and meets the description of HMOs specified by the local authority in the designation will, subject to limited statutory exceptions, require a license under Section 61 of the 2004 Act and will be regulated according to that license and the provisions of the 2004 Act. Well, that's an overview. That will give you a flavour of what Part 2 is about if you didn't have one before this. Let's dig down and look at some of the details of Part 2. The key provisions when it comes to additional HMO licensing, sections 56 to 60 of the 2004 Act, and again section 254, which gives you the definition of HMOs. Question: what area or areas can be covered by an additional HMO licensing designation? Well, the 2004 Act gives the local housing authority on the face of it a very broad discretion. So it can designate either the area of its district or an area, or indeed areas of its district, according to the evidence that it has. There is only one ground or condition on which a designation can be made, provided for in section 56, and that is that a significant proportion of the HMOs of a particular description, for example, section 257 HMOs or smaller HMOs above commercial premises, are being managed sufficiently ineffectively as to give rise or be likely to give rise to one or more particular problems, either for those occupying the HMOs or for members of the public. Now, a few words about those provisions. Before I come on to the ground or the condition and say a few things about that itself, it's worthy of note that by section 56, subsection 4, a local housing authority has the power to make a designation which applies to all of the HMOs in its area. So it can make its entire district as subject to additional HMO licensing for all of the HMOs in its area. However, to do so lawfully, it would require evidence that all of the HMOs in that area were being managed sufficiently and effectively so as to give rise to one or more problems for either HMO occupants or the public. And that brings me on to the focus of the ground or condition provided for in section 56. The real focus of the condition is essentially the poor management of houses in multiple occupation, to which mandatory HMO licensing doesn't apply. And as you will see from the condition as set out above on the slide here, it does require a causal connection between the ineffective management of HMOs of a particular description and at least one problem for either the occupants of the HMO or the public. Now, I'll come back to this question towards the end of the webinar, but it has been asked, a very pertinent question, if I may say. How does the local authority establish that causal connection? What kind of evidence is required? To my mind, and I provide this, any views expressed in this webinar by way of educational purposes as opposed to advisory, the local authority requires sufficient evidence to be able to establish a correlation, at the very least, between the ineffective management of HMOs and the problems to which they give rise. It is, as has been pointed out in a number of cases challenging licensing designations, really quite difficult to establish a solid causal link or connection necessarily between ineffective property management and social ills in the area of the property. Nonetheless, the local authority will require sufficient evidence to establish a rational, if not cogent, correlation between the ineffective management of properties, in this case HMOs, and the problem or problems to which section 56 refers. It's also worthy of note that the provision requires only a significant proportion of the houses in multiple occupation of a particular description to be managed ineffectively with problematic results. That, of course, begs the question, well, what is a significant proportion? Well, the dictionary definition of significant is sufficiently numerous to be worthy of attention, which is arguably more helpful than the definition given in homelessness litigation recently by the Court of Appeal, which is that significant means not insignificant. Where does that take us? Well, the likelihood is that as long as you are able to establish as a local authority that a sizable number of HMOs are causative or likely to be causative of a problem for HMO occupants or the public, then that's surely going to be worthy of attention in my view, and therefore probably significant. That leads me on to a last point for the purposes of this slide, and that is that the provisions do not require the ineffective management of HMOs to be causing problems at the time of designation necessarily, provided they are likely to do so. And you'll see that from the condition itself, that the HMOs must be managed sufficiently and effectively as to give rise or be likely to give rise to one or more particular problems. And what that is intended to enable local housing authorities to do is to identify and anticipate in advance, and importantly, take steps to prevent the problems and risks to which the ineffective management of HMOs will likely give rise. And that comes back to the rationale for regulating HMOs in the first place, which is that HMOs were, on empirical evidence, proved to be the most risky type of accommodation. And accordingly, you might think it appropriate that local housing authorities are in a position to be able to anticipate and prevent any such risks if they are able to do so. And so there is an anticipatory aspect to the condition for an additional licensing designation. So what further preconditions must the local housing authority satisfy before it can make an additional HMO designation, licensing designation? Well, there are 6 in total. So first of all, it must ensure that the exercise of its power is consistent with its overall housing strategy. That may be perceived to be problematic for local housing authorities in England, whose for a while now have not been obliged or required to have housing strategies. Nonetheless, in my view, any designation should be consistent with whatever strategy the local housing authority has regarding housing. In other words, it would be advisable, I think, to follow the spirit of the law, if not its letter, insofar as it applies to England. Secondly, the local housing authority must seek to coordinate its approach with its approach to homelessness, empty properties and antisocial behaviour as it affects the PRS. Now, that's not a particularly difficult condition to satisfy usually, given that through the process of licensing and regulating privately rented properties, local housing authorities will generally give themselves a wider range of accommodation into which, for example, to discharge homeless persons by way of private rented sector offers. The regulation and licensing of the PRS tends to limit the churn in the private rented sector and provide some stability for the occupants of privately rented accommodation. And of course, through license conditions and their enforcement, local housing authorities are able to impose upon the managers of PRS accommodation an obligation to deal effectively with antisocial behaviours. So, as I say, not a difficult condition to satisfy. Where local housing authorities tend to receive more representation, certainly at consultation stage, and perhaps more objections to licensing, is when it comes to the next precondition, which is not making a designation unless the LHA has considered whether there are other effective methods of dealing with the problem. So, as I say, the availability and effectiveness of other means of addressing problems that the local housing authority has identified is a critical condition for local housing authorities to consider, and I would suggest they need to consider each and every possible alternative with real care. And that may be, for example, the one that's typically raised by landlord representatives, that's the availability and effectiveness of landlord accreditation schemes in the local area. It might be the exercise of Part 1 powers under the 2004 Act, that's dealing with housing hazards by way of hazard awareness notices, improvement notices, prohibition orders. It might be the use of statutory nuisance powers under the Environmental Protection Act 1990, or indeed the use of closure orders and other remedies under the Antisocial Behaviour, Crime and Policing Act 2014. In short, there are numerous possible mechanisms by which to address potentially any particular problem that the local authority identifies. And what they must do, what you must do, local authorities who are listening, is identify all of the potential alternatives and consider very carefully why individually and collectively they are not sufficient to deal with the problem that the local authority in the private rented sector faces. and that should form an important part of any consultation document, and indeed any later submission to the Secretary of State. Fourthly, the local housing authority must consider that the designation will significantly assist them to deal with the problem. Again, that's not a particularly difficult condition to satisfy. And then critically, a point to which we will come back in due course, they must take reasonable steps to consult persons who are likely to be affected by the designation, and then consider any representations made in accordance with that consultation exercise that are not withdrawn. So if you are looking to designate an area that is subject to additional, or indeed, as we'll come on to see, selective licensing, then these are the additional preconditions that you need to check and make sure that you have satisfied before you go ahead with any consultation, I would suggest, in the first place, and then subsequently designation. So let's take a look at general approval or confirmation. And as we'll see, there is a critical distinction between the way this is dealt with in Wales and England. As indicated right at the start, designations require either general approval by the Secretary of State or the Welsh Assembly, or if there is no general approval, or that the scheme doesn't fall within a general approval, then confirmation by one or other body. In England, since 2015, general approval has been granted for additional HMO licensing designations, provided only that the LHA has consulted persons likely to be affected by it for not less than 10 weeks. And you'll find that general approval, and indeed that for selective licensing, in the Housing Act 2004, licensing of houses in multiple occupation, and selective licensing of other residential accommodation, England, general approval 2015. And yes, I did that without taking a breath. In Wales, the position is fundamentally very different. General approval is, as indicated at the start, given for all additional HMO licensing designations under the Housing Act 2004, additional HMO licensing Wales general approval 2007. The consequence of which is that ministerial confirmation for additional licensing designations is rarely required, whether in England or Wales. In Wales, because general approval is given unconditionally, and in England, because provided the local authority consults all those likely to be affected for not less than 10 weeks, then it will have general approval for any additional licensing designation it chooses to make. Let's deal briefly with the duration review and revocation of additional HMO licensing designations, and a few of the more technical aspects post designation. So take a look at section 60 of the 2004 Act for these provisions, but in summary, especially as confirmation is rarely required for an additional HMO licensing designation, they'll usually come into force on the date specified by the local housing authority in the designation itself. But importantly, that date cannot be earlier than 3 months after the designation is made. So there is, if you like, a 3-month adjustment period before it can begin. The designation, as many of you will know, cannot last longer than 5 years from the dates on which it comes into force. Otherwise, it needn't last 5 years, and it will come to an end, in fact, on the date that is specified by the local housing authority. So, for example, where a problem has arisen in a particular area of a district, which is not subject to additional licensing, but another area of the district is, then what the local housing authority might choose to do is make a short designation in the latest area, so that the commencement of any new designation that covers both areas in future, designations will commence at the same time. So, as I say, it needn't be 5 years, and the local authority can tailor the length of the designation according to its needs, provided it has a rational basis for doing so. Periodically, from time to time, local housing authorities must review the operation of their designation. I would suggest an annual review is probably sufficient for that purposes. Anything else perhaps would become onerous and unduly costly. And the local housing authority may revoke a designation following a periodic review. But the purpose of that, of course, is so that the local housing authority ensures that the operation of the designation is having the desired effect, that any tweaks that need to be made to it to make it more effective can be made, and that if in fact the problem that it was designed to address has been resolved, then the designation can be revoked. There are, as again many of you will know, notification requirements that unsurprisingly follow the making of a designation to ensure that the public and anyone affected by it is aware that it's been made. And you will find these provisions in section 59 of the 2004 Act insofar as they apply to additional licensing, and in secondary legislation, being the licensing and management of HMOs and other houses, miscellaneous provisions, England, or as the case may be, Wales regulations 2006. In short, as soon as a designation is confirmed, or if confirmation isn't required, then when it is made, the local housing authority must publish a notice in a prescribed manner, stating that the designation has been made, the details of any ministerial confirmation that was required, or if it was applicable, the general approval that applied, the date on which it comes into force, and any such further information as is prescribed. And under Regulation 9 of the 2006 regulations, as they apply to either England or, as the case may be, Wales, there are certain prescribed requirements, such as, for example, publication in a certain number of local newspapers in the area of designation and around it. And a copy of the designation and any prescribed information must be made available to the public while that designation is in force. I'm not going to take you in any greater detail through the provisions of Regulation 9 because they are a bit technical and frankly a little bit dull. But if you need to know the notification requirements, you have the provisions at which you need to look. Now, designation also brings with it several general duties on behalf of local housing authorities, which are set out in sections 55 and 61 insofar as they relate to additional HMO licensing. There are 4 of them under Part 2. The first is to make such arrangements as are necessary to secure the effective implementation of Part 2's licensing regimes. That's both additional and mandatory HMO licensing. The second is to take all reasonable steps to secure that license applications are made in respect of HMOs, which are required to be licensed under Part 2 but aren't. The third, to ensure that all license applications and other issues falling to be determined by them under Part 2 are determined within a reasonable time. And these last 2 general duties are ones to which we'll return in the second of our webinars on license applications and fees, because they come back into play in that regard. And then lastly, under Part 2, to satisfy themselves as soon as is reasonably practicable that there are no Part 1 functions that ought to be exercised in relation to HMOs for which license applications are made. Now, this latter obligation is one that isn't replicated in Part 3 that is selective licensing. And again, its inclusion in Part 2 reflects the far greater risk that Parliament ascribes, and indeed ascribes, to the types of hazards that are found in HMO settings generally and their potential consequences. And so where there is an additional HMO licensing designation, there is this additional burden duty on local housing authorities to consider to what extent Part 1 functions to address hazards should be exercised. So successful designations under Part 2. Let's look at some of the things that you can do to ensure that you have a smoother process of designating your area as subject to licensing. Well, first and foremost, and I've only made 2 points on this slide, is make sure that you evidence the designation properly. Remember, as indicated previously, that the focus of section 56 is on the ineffective management of houses in multiple occupation, and in particular on HMOs to which mandatory HMO licensing doesn't apply. For example, smaller and section 257 HMOs. And the focus really isn't, or is not merely, on the existence of problems in an area that happens to be HMO heavy. Okay, so there has to be, as the second point indicates, some causal connection or a likely causal connection between the ineffective management of HMOs of a particular description and one or more problems. So one problem will be sufficient. Obviously, if there are more, then the more cogent the local housing authority's evidence is likely to be. And that the types of problems can, as indicated previously, can range. Part 2 doesn't specify them or prescribe them. So it could be, for example, housing hazards, nuisance, environmental issues like waste disposal, graffiti, ASB crime, you name it. That list there is my list, and it's certainly not exhaustive. But importantly, as indicated before, although local housing authorities can, in principle, make a designation such that it applies to all HMOs in the area or indeed the area of their districts, it really is important to try to identify the particular class of HMOs that is causative of the problems. Now, local housing authorities can do that using a range of data. And again, this list is not exhaustive, but merely provides illustrations. So, for example, local housing authority records of hazards that have been identified upon a housing survey or upon inspections of properties under Part 1 functions or indeed under Part 2 functions. It can be based upon records of ASB complaints made to local housing authorities where, for example, they can be tied to the management of HMOs. You may derive that information from licensing, for example, where under a previous designation there have been a significant number of breaches of license conditions or failures to license HMOs in the past, or indeed management orders, and of course police records. So there's a range of information from which you can draw evidence of the type of HMO that is really causative of the problem. And again, to my mind, sufficient evidence to establish a rational correlation, if not a cogent correlation, between HMO management and the problems that exist should be sufficient. And again, Part 2 only requires a significant proportion of that class to be problematic. So you certainly don't have to demonstrate as a local housing authority that all of that class are problematic. That is causing the problems either for the occupants of the HMOs or members of the public, so long as a significant proportion do. Consultation, I'm going to return to at the end of this webinar because of its importance, but again, lawful consultation really is, as indicated on the slide, a cornerstone of designating an area as subject to either additional or selective licensing, and it's absolutely critical that local housing authorities get it right. But as I say, we'll return to that in due course. That deals for the moment with additional HMO licensing, and I'm going to turn now to selective licensing designations. And we'll follow the same structure as we did for additional licensing for reasons of accessibility. So by way of an overview, sections 79 to 81 we're now dealing with Part 3 of the Housing Act 2004, provide the power for local housing authorities to designate areas or the area of their district as subject to selective licensing. That is to regulate houses that fall outside of Part 2 of the 2004 Act. And they might be HMOs, they might be self-contained flats, they might be terraced houses, so long as they fall outside of Part 2. Selective licensing was originally intended to address the impact of substandard privately rented accommodation and substandard management in areas of low housing demand and problems caused by antisocial behaviour and antisocial tenants. And as we'll come on to see in due course, low housing demand and antisocial behaviour are the two general conditions or grounds for designating an area as subject to selective licensing. And they've since been extended by 4 further grounds or conditions by regulations made in 2015. We'll come on to those in due course. Critically, however, neither borough-wide nor large-scale designations are now approved generally in England. The position in Wales, as I indicated at the start, is different because, like additional licensing designations, all selective licensing designations made by LHAs in Wales have general approval under the 2007 general approval issued by the Welsh Assembly. Again, consultation is required before any designation is made, as with additional HMO licensing. And again, of course, if a house, once a designation is made, falls within the designation area and is not otherwise exempt, then the person managing or having control of it must obtain a license. And if they don't, or if they breach license conditions, the local housing authority can enforce the licensing provisions of the 2004 Act by way of enforcement action. So that gives you a snapshot of selective licensing. Now, let's do a deep dive into some of the detail of selective licensing designations, the provisions of which you'll find, as I indicated, Part 3 of the 2004 Act, sections 80 to 84 in particular, and section 99, which gives you the definition of a dwelling and a house for the purposes of Part 3. And then the secondary legislation, which provides additional conditions, that's additional to the general conditions given under the 2004 Act itself. In England, that's the Selective Licensing of Houses, Additional Conditions England Order 2015, and in Wales, the 2006 order. Identically with additional licensing designations, a selective licensing designation may be either of the area of the local housing authority's district or an area in that district. But as we'll come on to see, obtaining confirmation of a large-scale selective licensing designation is now more problematic than it used to be before 2015, in England at least. As for the grounds or conditions on which a designation can be made, well, in both England and Wales, there are two identical general conditions, as indicated previously. One is that the area is or is likely to become an area of low housing demand, a ground which rarely applies in the area where I generally practice, geographically at least, that is in London, but is certainly pertinent elsewhere in England. And secondly, that the area is experiencing a significant and persistent problem caused by antisocial behaviour that some or all privately rented sector landlords are failing to combat. Now, one thing to note here, certainly with the antisocial behaviour provision, is that like the condition for designating an area as subject to additional licensing, the ASB condition does require not just the existence of a problem with ASB, but evidence that some PRS landlords are failing to address it, to combat it. So there are two elements to it. There's an antisocial behaviour problem, but that in and of itself is not enough. There must be some evidence that PRS landlords are not doing enough to address that problem. And again, evidence sufficient to establish a correlation based upon evidence available to whether it be the police or the local housing authority should be sufficient, though the stronger the local authority's evidence, obviously the better their case will be. A further note is that the general conditions, and this is something that is frequently overlooked by local housing authorities, do not require there to be a relatively high proportion of properties in the private rented sector. That precondition only applies to the additional conditions on which a selective licensing designation can be made. So when it comes to low housing demand and antisocial behaviour, it is sufficient, subject to the additional preconditions that we'll look at in a moment, for there to be an area of low housing demand or a problem with antisocial behaviour that is not addressed sufficiently or adequately by PRS landlords. So there are, as indicated, additional conditions that have been prescribed by secondary legislation. I'm not going to take you through them in great detail because of time constraints. But in England, they are different in England and Wales. There are 4 such conditions. Now, importantly, as indicated on the last slide, all of the additional conditions require a relatively high proportion of properties in the private rented sector that are let on assured tenancies or licenses. Now, currently, there will be a relatively high proportion of properties in the PRS if the PRS makes up 20% or more of the total housing stock in the local housing authorities area. But local housing authorities are encouraged in guidance to consult the most recent housing surveys to see what the current proportion of the PRS is to the total housing stock in England generally, and indeed in their area. The provision that the properties are required to be let on assured tenancies or licenses is really not a very difficult condition to satisfy, given that the default tenancy in the private rented sector under the Housing Act 1988 is indeed the assured short-hold tenancy, which in my view is sufficient for these purposes. When it refers to assured tenancies, in my view, that is a reference to assured tenancies of all descriptions, whether it be short-hold or non-short-hold. In Wales, the additional conditions are different, and in brief they are that the local housing authority has declared the area to be a renewal area, or has provided certain housing assistance under the 1989 Act, or that there is a relatively high proportion, that is a minimum of 25% of properties in the private rented sector, and provided one or indeed both of those conditions is satisfied, then a local housing authority in Wales has the power to make a selective licensing designation on additional grounds. So when it comes to the additional preconditions and matters such as approval and confirmation, essentially the same provisions will generally apply for selective licensing as apply in respect of additional licensing. So as you'll see from the first point on the slide, the same preconditions apply under Part 3 as under Part 2 when local housing authorities exercise their power to designate an area subject to selective licensing. And indeed under Part 2, as under Part 2, local housing authorities have the same obligations to consult and consider representations about the designation proposal, and I, as indicated, will come back to that shortly. Again, for effect, designations require either general approval or confirmation, and that's provided for by Section 82. And as indicated previously, in Wales, confirmation is not required because, in fact, Welsh authorities have general approval for any selective licensing designations they make. As many of you will know, the position in England is more nuanced and more difficult generally, and I'll come on to that on the next slide, because the Secretary of State has, since 2015, given only very limited general approval for selective licensing designations. Again, the same provisions apply in respect of the duration, the review, revocation, notification of selective licensing designations as applied to additional HMO licensing designations, and indeed the duties, the general duties that are owed by local housing authorities are also identical, save as indicated for the duty that obliges local housing authorities to satisfy themselves about the need to exercise any Part 1 functions. That is not replicated in Part 3, reflecting, as I indicated previously, the fact that privately rented accommodation other than HMOs is considered to be of less risk to occupants and members of the public than HMOs themselves. So approval, confirmation and guidance. So as I indicated, since the 1st of April 2015 in England, the current general approval will apply only to selective licensing designations that whether singly or jointly cover no more than 20% of the local housing authority's geographical area, or affect no more than 20% of the privately rented homes in that area. And you'll find that in the general approval 2015 as set out on your slide. For any other designation that falls outside of that bracket, the Secretary of State's confirmation is needed. And as many of you will know, the process of obtaining confirmation is a laborious, time-consuming and often vexed process in which there is a degree of toing and froing between the local housing authority and ministry before confirmation is granted, and often a significant period of delay. There is non-statutory guidance which provides some direction when it comes to seeking confirmation, and you'll find that in the selective licensing in the private rented sector, a guide for local authorities guidance issued by, as it then was, the DCLG. Two critical points to take from that guidance, which is that applications for confirmation will have to set out very clearly their rationale for adopting a large-scale designation. The general inclination of the ministry has been since 2015 to look with caution on any large-scale designation, and so the ministry will usually require not just a very cogent rationale and reasoning for it, but also, as indicated on the last point on the slide, really robust evidence to support the reasons for making the decision. And when it speaks of robust evidence, that's not just concerning the evidence that supports the conditions for making a designation, but actually the reasons for exercising the local authority's discretion to designate. So, for example, why is it that selective licensing will benefit the community? Why is it that selective licensing in particular, whether individually or together with other initiatives, will address the problem that it's designed to address in this particular case? So it is, as I say, a rather vexed process, and one in respect of which shortcuts cannot afford to be taken. The guidance goes on, and perhaps importantly, and I'll read this out because it really it is quite significant, as follows: at paragraphs 59 and 60, the Secretary of State will take into account in deciding whether to confirm a scheme the robustness of the proposed measures to ensure compliance. In particular, the Secretary of State will expect to be assured that there are systems in place to monitor compliance and enforcement measures are in place where there is non-compliance. He will also take into account, when considering confirmation of the new scheme, whether there's been sufficient compliance with other licensing schemes operating in the local housing authority area. It's important that licensing schemes that exist are robustly enforced, and if a local housing authority is unable to show compliance, this will cast doubt on its ability to ensure compliance with the application scheme. Now, a number of points to take from that, and that is, as indicated in respect to the last slide, it's not just robust evidence of that the conditions for a designation are fulfilled, but actually that the local housing authority has a good track record, or will, for X, Y, or Z reasons, have a good track record of not just implementing the licensing designation, but enforcing it with a view to improving conditions in the area. And I cannot emphasize enough the importance that the Secretary of State places on that evidence. So you will need, for example, if you're a local housing authority, to look at the way in which you have implemented previous designations, the way in which you've enforced them, the success that you've had, by reference to enforcement action that you've taken, by reference to the number of licenses that have been granted, by reference to the number, for example, of financial penalties that have been imposed, or prosecutions successfully undertaken. Because the Secretary of State will want to see that you can be relied upon to implement and enforce that designation, and indeed that they are making a difference. And I'll come back to that in due course on the last slide about selective licensing. Speaking of which, some tips for successful designations under Part 3. The top of that slide should not read Part 2, of course, it should read Part 3. So again, evidence and rationalize the designation properly. Here, you do not need to go into the process of designation blind. Look at the statutory provisions, because they will provide you with a guide and indeed enable you to create a checklist so that you can ensure that each statutory requirement is fulfilled and that you have evidence to support it. And again, don't take any shortcuts, because the Secretary of State will come back to you if the ministry perceives that there is a gap in your evidence base. That may sometimes require you to dig down as deep as evidence concerning lower layer super output areas, as opposed to just ward-based data. But you should go into that exercise with a view to making the evidence as robust as you possibly can. Consult lawfully. Again, I'll come back to that momentarily. But just as importantly as providing a cogent evidence base and a cogent rationale for your designation, make your submission to the Secretary of State accessible and cogent. Make the ministry's life easy. So when you submit your application, provide that submission with a logical, easily accessible structure using summary headings, subheadings, tables, etc., a contents page, pagination, plain English, be concise, don't repeat matters that have previously been dealt with, and the real nuts and bolts of the submission, the evidence base, your record of enforcement, for example, summarize it by all means, and do summarize it in your submission, but append that evidence conveniently to the application, so that if the Secretary of State or the Ministry needs to look at it, they can easily turn to it. And as I indicated before, emphasize the local housing authority's record of licensing implementation and enforcement. But just as importantly, and something that local housing authorities overlook almost every time, emphasize what selective licensing, what additional licensing will bring to the community that is additional to what is already provided for by the local housing authority. What extra will licensing enable the authority to offer to the community? For example, as a result of the licensing fees, will the local housing authority be able to offer additional support for tenants by employing 1 or 2 extra tenancy support officers? Will the local housing authority, as a part of its licensing designation, lay on regular landlord training facilities, whether it be webinars like this or in-person face-to-face events that enable landlords to educate themselves about licensing and about broader issues of landlord and tenant law and tenancy management. That is an extra community offer on which the Secretary of State, the Ministry, will often look favourably when considering any application for confirmation. And will, for example, licence holders be entitled to discounted community services, for example, waste disposal facilities, where a licence is in place. So don't forget the added benefits that a licensing designation and the income that it generates will enable the local housing authority to lay on. Consultation. The last 2 slides of today's webinar will look at consultation. And I've left it to last because it is of critical importance, and the lawfulness of additional and HMO licensing designations really depends on it. Here I've highlighted for you the key points taken from the key authorities. So first of all, what are known as the Sedley criteria taken from the case of Gunning, and that is that consultation must occur at a time when the authority's proposals are still at a formative stage. So the local authority cannot go out to consultation with a totally fixed idea as to what its ultimate designation is going to be. It must still be capable of variation upon consideration of consultation responses, for example, or upon the admission of further evidence. The local authority must give sufficient reasons for its designations so that consultees are able to consider and respond to the proposal intelligently. A point that was returned to in the case of Pete, listed below. Adequate time must be allowed for consideration and response, not generally a problem under the 2004 Act, because in order to have general approval, of course, a designation must be consulted about for a minimum of 10 weeks. Whether that be in respect of additional or selective licensing, and then responses must be conscientiously taken into account. Again, not a problem because the 2004 Act requires that. Now, the Gunning case did not concern licensing under the 2004 Act, but as those who join us from Hyndburn know, the case of Pete certainly did. And this was a challenge to the local authority's licensing designation, on the premise that the authority had not consulted fully or properly about its proposal. And in that case, which I would encourage you to read because it really is salutary, the court outlined 4 particular things that the local housing authority must identify with precision in its proposal. First of all, the proposed area of designation. So what area or areas will the designation cover? The details of the proposed license conditions, because they will of course impose obligations on license holders and subject them potentially to criminal liability. It's critical therefore that potential license holders know what they might be in advance so they can comment on them. Details of the proposed fee structure, an often thorny and vexed question on which local housing authorities frequently receive a lot of representations. It's important that the public is able to comment on them. And again, returning to the point I made in respect of sectorial confirmation, the reasons for introducing the selective licensing designation, not just the evidence that supports the grounds for a selective licensing designation, but why the local authority is exercising its discretion once the grounds are satisfied to bring one into force. So consultations about general principles will not suffice, and that's the real message that came out of the Peat case. We also learn a salutary lesson from the case of Regus. Crown on the application of Regus and Enfield London Borough Council. There was a case in which the local authority had made a licensing designation on the premise that it fell within the general approval that was then applicable because they'd consulted for a period of at least 10 weeks. In fact, what had happened is that the local authority had consulted properly for a period of 8 weeks and had previously engaged in what was termed a period of listening and engagement for a period of 2 weeks. And Enfield said that it was able to aggregate those two periods to form 10 weeks and therefore a period of lawful consultation. The court disagreed and said that it was not permissible to aggregate those two periods, not least because the prior period of listening and engagement was not a period of proper consultation. And so it needs to be a 10-week period for the purposes of general approval of full consultation in accordance with the guidelines given in Peat and in Gunning. For anyone looking to embark upon a consultation exercise, I would strongly encourage you to read the case of Croydon Property Forum and Croydon London Borough Council. That was also a case in which there was a challenge to the local authority's licensing designation, again on the premise that it had not consulted properly about its proposal. That claim failed because on the facts of that particular case, Croydon had consulted thoroughly and extensively about its licensing designation in a way that I would suggest is exemplary. The manner in which Croydon went about that exercise, the way in which it consulted using numerous different means, both within its borough and outside of the borough, it provides, as the slide indicates, a salutary lesson for any local housing authority looking to embark on a consultation exercise. Read it, absorb it, follow the steps that Croydon took, and you won't go far wrong. And then lastly, some solace, if I can provide it, is that don't lose heart, because the duty to consult is a duty to take reasonable steps to consult those likely to be affected by the designation. It is not a duty to take every step, nor indeed all steps, nor indeed all reasonable steps to consult those people. And so there is a margin of, if you like, a margin of appreciation that is given to local housing authorities in the way they go about their consultation exercise. And generally speaking, unless something has gone really quite badly wrong, the courts will be reluctant to intervene. That we see demonstrated in the Rotherham Action Group case, where, as I say, the court was slow to intervene, despite the fact that I think on the facts of that case, there was an allegation that the evidence base for the designation was not sufficient. So those are the main principles that I would leave you with in respect of consultation. While it has been, I appreciate, a rather whirlwind tour of selective and additional licensing, I hope it gives you some flavour of the requirements that local housing authorities will need to meet and the duties that they will have when a designation is made. So I'm going to look very briefly at some of the questions that most of which have been sent in advance of the webinar concerning designations. I'll cover as many of those as I can in the next 10 minutes. So the first of those is, what are the most common objections to licensing designations, and how do local housing authorities overcome them? Well, as I indicated previously in the presentation, one of the principal objections that is made is that licensing is not necessary because there are adequate powers available to the local authority and adequate alternative means of addressing the problem that the local authority has identified. And that is why, in my view, it's so critical that local housing authorities look at all of the potential possible alternatives to licensing when they go out to consultation, and indeed when they apply, if they have to, for confirmation from the Secretary of State. So consider each of them with care, and consider why each of them individually and why all of them collectively will not enable you as a local authority to address the problems that you want licensing to solve. So the common objections, alternatives, and the availability of them, the effectiveness of them, that's certainly a way that you can overcome them. And for example, it's often pointed out that the council has powers under Part 1 of the 2004 Act to deal with housing hazards, and therefore licensing is unnecessary. Well, it does, of course, have powers under Part 1, but what those powers do not do is enable local housing authorities without more to regulate the management as opposed to resolving hazards in a private rented sector property. And they also do not impose on PRS landlords any proactive obligation to manage those, to manage their tenants for themselves, to manage the tenancies, to manage, unless, for example, an improvement notice is served or a prohibition order made, to proactively manage the hazards in their properties. Whereas, of course, licensing will enable local housing authorities to do that. How do you balance the long-term strategic objectives of licensing with the fact that licensing designations run for only 5 years and the confusion that redesignated can often cause? Well, I think it's probably right to point out that the strategic objectives that local authorities seek to meet by making a licensing designation are far longer-term objectives than a licensing designation in and of itself will account for. So, for example, dealing with homelessness, dealing with empty properties, these are long-term problems that long exceed a period of 5 years, generally speaking. But it is also recognized, I think, by most that licensing is also considered to be a long-term solution. And rarely is it the case that one designation alone, a period of 5 years alone, is sufficient to resolve the problems that the local authority has identified. And so the key thing to ensure the local authority keeps on top of when it comes to the end of one designation is, well, to what extent have those objectives been met? And do we therefore, a year prior to that designation ending, need to start preparing, in fact, probably more than a year before it ends, start preparing for the next designation to ensure a smooth transition from one designation to another? And so, as I say, it's really not uncommon for local authorities to see licensing as a long-term strategy and solution to their strategic objectives. How do you resolve the tension between the outcomes of an existing designation with the need for a new designation? What I think this question is driving at is when you, for example, present a case, whether in a consultation paper or indeed to the Secretary of State, that a second licensing designation is needed because there are problems in a particular area, how do you then square that with the need to demonstrate that your previous licensing designation has been successful? Well, this rather ties in, I think, probably with the answer to the previous question. That is that an individual licensing designation of 5 years is rarely alone sufficient to address completely the problems that were identified at the start of the original designation. And so really what the local authority is looking to demonstrate is that there has been an improvement since the first designation was made. Whether that be because there's been a reduction in complaints about ASB or a reduction in crime, or because housing conditions have improved. But generally what local authorities will see is that while there has been an improvement, the problem is not entirely resolved. Provided there is evidence to demonstrate that, and to demonstrate that the conditions for a further licensing designation are met, then generally speaking, there will be grounds, and it will be for the local authority to consider whether in the exercise of its discretion, a second designation is warranted. But the fact that the problems haven't been totally resolved ought not, in and of itself, and will generally not, be a bar to, or potentially even problematic to a further designation being made. Can you carve out a small area in an otherwise designated ward where, for example, there are no issues of antisocial behaviour or disrepair? The short answer to that question is yes. Yes, you can. And in fact, the evidence that you obtain for the purposes of your designation may require it, because if you can't demonstrate that a particular area of your district is affected by the problems, which would give rise to a ground for licensing, then you really ought not to include that area. And sometimes that occurs, for example, in small areas of a local authority district where there's been significant development, for example, since a previous designation was made, and most of the properties are now new build. Or, for example, where because a small area of the district is owned by properties that are exempt from licensing, for example, university accommodation, that small area, licensing cannot apply to it. So in those cases, what you would seek to do is really dig down into the evidence base, perhaps at lower super output area level, to assess the extent of the area that really is covered by the problem, and then set out your case for designating the affected area and the affected area only. What type of evidence can establish causation? This, in a far longer and, if I may say, very erudite question that was posed by, I think, Nottingham City Council, it is something I've touched upon previously. And it's right to say that, for example, in cases like Southern Landlords Association and Thanet, and indeed the case of Regus, it's been suggested that, if you like, direct evidence of a causal connection is not necessary, and that evidence sufficient to establish a correlation will generally suffice. And that position, it certainly accords with my understanding, although sometimes I know the Secretary of State takes a different position. Well, in those cases where the Secretary of State, for example, when you seek confirmation of a designation, is calling into question evidence of causation, first of all, you need to point out these authorities, and secondly, you need to point out, I think, that on a proper construction of the 2004 Act, it is sufficient for there to be a rational correlation between the evidence the local authority has obtained of the problem and any evidence it has of the connection between that problem and PRS properties in the vicinity. And as I say, that evidence may come from a range of sources. And if the Secretary of State persists, then unfortunately the result is the remedy is judicial review. But for resource and costs reasons, then you're far better off ploughing energy into persuading the Secretary of State at confirmation stage than having to challenge a decision refusing confirmation. I'm just going to check through some of the questions that I've received online while the session has been going. So, would funding limitations be a legitimate ground for dismissing alternatives to licensing, such as Part 1 action? For example, the staffing levels to address hazards across the PRS are not sustainable without license fee funding. That's certainly, in my view, a material consideration, and it really demonstrates that it's perhaps more that the income that is generated by a licensing designation will enable local housing authorities to offer a more proactive and effective service and more thorough service under Part 1 than would otherwise be possible. And I think that is a material consideration. It's not necessarily a reason for demonstrating that Part 1 powers alone are insufficient. I think when it comes to Part 1, local authorities are perhaps better placed relying on the fact that, as I mentioned previously, it doesn't enable local authorities really proactively to address hazards because they're generally reliant on complaints being made. Whereas, for example, licensing under Part 2 in particular really requires an inspection of the HMOs that are affected. And secondly, it really doesn't impose upon the managers and license holder, managers of PRS properties any proactive obligation to manage their tenancies and their tenants effectively, whereas of course licensing does. So that's perhaps the take that I would have on Part 1 powers as an alternative. Well, it's 12 minutes past 12, and that brings me to the end of this webinar. I hope that you found it helpful. As I say, it's the first in a series of 4 webinars on the subject of PRS licensing. The next will be, which will be next Thursday, will be on license applications and license fees and fee setting. And then for each of the 2 subsequent Thursdays, we'll have licenses and license conditions followed by enforcement. So thank you very much for joining me. As I say, any queries, anything that arises from this or anything in respect of which you want to instruct me, feel free to contact me on the email address or my clerks at teamdan@cornerstonebarristers.com. And I look forward to seeing many of you next week. Thank you very much. Bye-bye.